The first clause of the 15th Amendment says states can't discriminate on the basis of race. And the second clause, and that's the one I want to talk about, says Congress shall have the authority to implement this through, quote, appropriate legislation. The current Supreme Court, on a 5-4 vote, declares it unconstitutional. And they did so by principle, a court-made principle called equal state sovereignty. Now, the problem with that is, first of all, it's a made-up principle. It's not in the Constitution.
I was wondering if you could tell us a little bit about how you went about defending Article 5 in the Voting Rights Act, trying to push back a little bit, and maybe also your specific in-depth work in research on how even equality having been established within the frame of the law, we have to ensure that, as you do, for example, voting booths aren't moved and all these sorts of things, which really require a close attention to detail, which I think people don't realize when they're legislating so widely.
So could I give your listeners a little background?
Of course, sure.
Okay. It's all about the 15th Amendment to the Constitution, which was added to our Constitution after the Civil War to protect the voting rights of the freed slaves. That's what the 15th Amendment is for. It's very short. And the first clause of the 15th Amendment says states can't discriminate on the basis of race. And the second clause, and that's the one I want to talk about, says Congress shall have the authority to implement this through, quote, appropriate legislation. Now, that brought about a dramatic change in the relationship between the federal government and the states. Up until the 13th, 14th, and 15th Amendments, the federal government had very limited authority, and this amendment shifted power to the Congress to rid the country of racial discrimination on the basis of voting. And so, acting pursuant to the 15th Amendment, in 1965, Congress passed the Voting Rights Act, which had many provisions, and the one I think you mentioned is Section 5. And Section 5 said that certain southern states with a history of racial discrimination in voting, could not change any aspect of their electoral system. They couldn't change a voting district line. They couldn't even move a polling place without going to the Attorney General in Washington and proving that it was not discriminatory. And this law was dramatically effective in the South. And it was sustained, its constitutionality was sustained by the Supreme Court 4 times. Originally when the Congress passed it, and then 3 more times when Congress extended it. And it did so on the grounds that Section 2 of the 15th Amendment gave Congress all the power it needed over the states to prevent them from discriminating on the basis of race. So in 20 years ago, the Congress extends the Voting Rights Act again, and this time the current Supreme Court, the Roberts Court, on a 5-4 vote declares it unconstitutional. And they did so by using a principle, a court-made principle called equal state sovereignty. That is, that the states have to be treated equally. And because, what the Voting Rights Act did was it applied this preclearance only to certain states. So the court said that's not treating states equally. Now, the problem with that is, first of all, it's a made-up principle. It's not in the Constitution. And secondly, the court's own precedent said that this doctrine only applies to the admission of states to the Union, not afterwards. So the court took a made-up principle that its own precedent said did not apply to the current situation and used it to trump, pardon the expression, to override the very clear language of Section 2 of the 15th Amendment. So when you read, if you read the very first few Supreme Court opinions sustaining the constitutionality of Section 5, you'll read all about the evils of discrimination in voting based on race. That's what the court's talking about. If you read Shelby County, There's hardly any mention of that at all. And instead, it's all about state autonomy and protecting the freedom of states to change their voting laws. So the court in this case that's why I say that an originalist would have come out the other way. I can't think of a provision of the Constitution that's clearer than Section 2 of the 15th Amendment. Congress shall have the authority to enforce it through appropriate legislation. This isn't like Dobbs, the abortion case, where there was some debate about the underlying constitutional provision. Here, it's crystal clear in just, 14, 16 words. Yet this court found a way to basically disregard it.
Could you maybe, just for our listeners, briefly expand a little bit more on originalism, just so that some people who might not have that theoretical background get a bit more clued up on it?
Well, take this case. An originalist looks at the plain language of the Constitution,
okay,
and applies that. Now, this is the 15th Amendment. It's part of the Constitution, and it's very clear that Congress has this authority. And the other aspect of this is that previous Supreme Court decisions made it very clear that when it comes to voting and race, the courts owe a huge amount of deference to Congress because of the 15th Amendment. And the Supreme Court ignored all that. So that's why I say an originalist would have come out the other way.
Thank you. I'll move it again back to your book. I think you write optimism that racism is nearly over seems like a national pastime. That was one that stood out to us quite a lot. Could you, since we're discussing desegregation overall, could you maybe expand on your personal experiences and tell us about your work with the Office for Civil Rights and how you implemented desegregation?
Yeah. So I was the director of the Office for Civil Rights at the beginning of the Carter administration. And we enforced what is called Title VI of the Civil Rights Act, which prohibited racial discrimination in programs that receive federal funds. And that's basically every school district and university in the country. I had that job in the mid-1970s, and OCR then was basically responsible for enforcing the requirements of Brown versus Board of Education. That's the famous 1954 Supreme Court decision that struck down separate but equal in schools. And so we were using the leverage we had with school systems to force or to require them to desegregate. And then later, the desegregation movement moved to the North and the West. These were school systems that hadn't been illegally segregated, but were nonetheless racially segregated because of demographics. And there were major efforts, and I worked on some of them, to desegregate those school systems, including by involving the predominantly white suburbs in the effort. But by that time, the three branches of government, the courts, the Congress, and the president, that had uniformly worked together to require desegregation in the 50s and 60s and 70s, those three branches of government were now opposing or making desegregation efforts more difficult. So the United States, 4-decade experiment with school desegregation reached its peak in the 1980s and then declined. And in most big school systems now, the segregation is just as bad as it was at the beginning.
Yeah, what's maybe the personal kind of feeling that you have about that? Clearly, something that you are very linked to throughout your life. Or what relevance is up to you?
Yeah, I mean, I'm disappointed. I believed in equal educational opportunity, and that's best achieved in desegregated school systems. And the research on education proves that I'm correct about that. Desegregated education is good for Black and white students, but Americans' attitudes towards this have changed. That's the quote you read from my book. People are tired of civil rights. White people think, we've dealt with this issue long enough. There isn't much discrimination anymore, and forcing people to get on buses to go to school is a bad idea. So the country has walked away from that. Starting with Richard Nixon. Richard Nixon ran in 1968. He ran for election on the basis of what he called his Southern strategy, which was anti-busing, and it paid off big time for Richard Nixon. That's largely what got him elected. And that began the dramatic change in the public attitude towards civil rights and desegregation in our country.
For 54 years, they were trying to get Roe v. Wade terminated, and I did it, and I'm proud to have done it.
So the checks and balances, which have been so critical to preserving our constitutional system and individual liberties, largely don't exist now. My concern is that in the past decade, this Supreme Court has been less faithful to those principles than we would like. And that's dangerous for a democracy. This book tells the story of so many people that people see their own lives in my book.